now that you've gone and you're thinking about commercialization and product development, we're going to talk to Linda Hutchison about intellectual property and how you protect your idea.
Okay, thanks, Chad. Let's get this going. Is it going? Okay. So again, thank you, and thank you to Root 3 Labs for hosting this event. My name's Linda Hutchison, and I own Hutchison Law, where I practice intellectual property. And what I'm going to be talking about is leveraging your intellectual property. I know we're talking about hardware products, but it's going to be talking about sort of for anything. There's going to be a focus on patents, but I'm also going to hit on trade secrets, trademarks, and copyrights. I'm really not here to give definitions of things. What I'm hoping to do is have you see them in action, and then you can decide the value of them, and the definitions will sort of come through as you see them in action. So what I want to start with is actually a story, and it's a story about intellectual property and large-scale manufacturing. I know we're talking about more small scale, but just to set the stage, let's go with large scale. When I graduated from college, I was a chemical engineer, and I went to work for Procter & Gamble in Green Bay, Wisconsin, in their manufacturing plant, and specifically, I was in the Charmin toilet paper making area of the manufacturing plant up in Green Bay. So if you didn't know this, Green Bay happens to be the Fox River and the East River happens to be one of the most, or at that time anyway, the most densely populated paper-making areas in the world. And so our plant, the Procter & Gamble plant, was just one of many that were around there. And they all used this sort of common process when they were manufacturing paper, whether it's Charmin or something else. And the process had to do with vacuum, press, and then conduction. So if you don't know this, paper, any kind of paper generally is formed from wood and water, and you mix them together, you get a slurry, which we call pulp. And then the whole process of paper manufacturing is sucking the water out or getting rid of that water while the fibers of the wood form a certain way to result in the paper qualities you want. And they're going to form, or the type of wood, they're going to form in a certain way to get a certain softness or a certain strength, or whatever it is that you're looking for. But in general, if you're putting that pulp, that mixture on something, you're going to start with vacuum, and you're going to suck some of the water out. You're going to press those fibers with the water, and you're going to kind of press the water out of there. And then you're going to put the wet fiber kind of mash onto some sort of hot surface, sort of like cooking a pancake on a skillet, and you're going to end up making paper. So on my first day, or probably my first week with Procter & Gamble, my boss was giving me a tour of the manufacturing area that I was going to be working in with the machine that I was going to be aligned with. And he pointed out that, hey, what we have here is called blow-through drying. And he was really excited about that. And in fact, what he did is, oh, am I using the wrong way? Is he talked about how it was patented technology. And at the time, that didn't mean a heck of a lot to me, but when he explained it, he said, by having this patented technology, all those paper manufacturers that you're driving by in order to get to work, all our competitors that you see along the Fox River, that means that they can't do the same thing. And it turns out that this blow-through technology is what makes our Charmin really soft. So all those competitors can have to figure out some other way in order to make their paper as soft as Charmin. And if they can't, that means that we, as Procter & Gamble, have a really great advantage in the market. So by having this patented technology, there was a quality performance that Procter & Gamble was able to take advantage of in the market. So again, what did it do for Procter & Gamble? Well, a patent is a government grant of a right to stop others from making, using, or selling your claimed invention. So they were able to, Procter & Gamble, with a patent on that drive-through technology, was able to stop all their competitors from using the same technology. And so they had an edge with respect to softness, which is a great quality to have when you're thinking about Charmin. All right, so what does a patent look like? when I'm talking intellectual property, we're talking intangibles here, but there are things that the government is going to give to you and expect from you that will result in these rights. So this is the patent from 1967. These days patents look a little bit different, but this is the one for Procter & Gamble. And if, for instance, on the front page of a patent, you're going to have a drawing, a general drawing of what's going on. These days, you're going to have a lot more text on the front, but you can see here that if you look at item 22, that is actually the blow-through drying technology. And so within the patent document, there's going to be a whole lot of description about that dry-through technology. So here, you know, there's a lot of words that are in this patent. And in fact, when Chad and Todd were talking about, you know, the discovery and the product development, when an inventor comes to me and says, I want to file a patent application, I'm like, you have to give me all the information because I have to write a document about this. I have to, you know, prepare the application. There might be some examples or invention, you know, experiments that have gone on. You're going to want that in your patent application as well if it supports that you've created something novel. And at the very end of your patent, if your patent application, if it gets issued, you have at the very end of your patent are what are called your claims. And this is where the rubber hits the road in terms of the value of your patent. So when you have a patent, that means that you can stop others from making, using, or selling your claimed invention. So you look to the claims. So in this case, this is claim number 1 for this invention. And specifically, if you look at item number 3, you will see that it says part of this process is thermally pre-drying uncompacted paper web. So this is where they start, you know, with the novel aspect of using this blow-through drying technology versus using rollers that historically were pressing water out of paper. All right, so how does this apply to you? You know, this is a Procter & Gamble, this is a huge company, and they're stopping all these other manufacturers. Well, if you invent something useful and novel, you know, the same process applies to you and the same benefits apply to you. So for instance, you have something that's novel and useful, you patent it, and then all your competitors, whether they look like that or not, you're able to stop them from making, using, or selling your patented invention. And again, what's in the patent comes from the discovery, comes from the product development and the claims. So you really have to think about your business as far as what it is that you want to stop others from doing. But before I say, okay, now everybody go out there and file a patent application, I do want to pause and ask you some, you know, and ask you some questions. And this complements what's been said already, which is we're looking for that balance here, folks. We're not going to automatically just say, do this, do this, do this. You have to really think about your business and your strategies. So for instance, one thing might be, is my invention more valuable to my business as a secret? And if that's the case, you're not going to want to file an application to patent your invention because that makes your invention public. You're going to want to think about controls for trade secrets. Also, let's look at the bottom middle diamond there. It says, well, you know, do you actually think you're going to sue anybody? I mean, that's what the patent is. When we're saying we stop others from making, using, or selling an invention, one of the things you have to do in order to, if someone's actually selling your invention or making your invention, to stop them, you have to bring in the law. You have to bring in the judicial system. If you're not comfortable suing people, you might say, well, what's the benefit of filing a patent and getting a patent application? Well, then I want you to look at the diamonds on either side of that. Is there a situation where you need to demonstrate your expertise in this industry? Well, a patent does that very, very well. And do I plan to sell or license my invention? Again, if you get to the point of product development, a lot of times, like the larger companies will say, thank you for doing our R&D for us. Thank you for getting it to the point where we can now scale it up and sell it. But at least you've taken, you know, thank you for taking that part on. So there are pros and cons in, you know, whenever doing a business decision-making process, you really have to balance a lot of things, your business strategy as well as, you know, your risks. All right, so let's look at this in action here. So you have a novel and useful invention, you patent it, your competitor sells a claimed invention, you can file a patent infringement claim against that person in court. What if your competitor sells the same exact thing you do, but without all the elements in your claimed invention? Well, then your patent doesn't apply. So they may sell the exact same thing, but your claimed invention had to go into such detail, and some of those details your competitor didn't include. So then your competitor isn't infringing on your patent. So in that case, you don't have patent infringement. So what is something you can do? Well, let's talk about trademarks. So imagine you have your product is on a shelf and you want to get your customers to your product. One of the great ways to do that is we start talking about branding, and you have a trademark, and a trademark is not just a graphic, and it's not really supposed to, and it should not describe what your product is. What it should do is act as a beacon to bring your clients or your customers to you. So you have this trademark that's on your product, and your customers know about you and your business based on your branding. So they start coming there, and they start to the shelf, and they start buying your stuff. Even though your competitor is selling the same thing, you figured out a way to get your customers to you. Well, what might happen? Oops. Well, your competitor will say, and this really does happen. Your competitor will say, that trademark is drawing customers to you. I'm going to use, kind of a similar one, I think, and I'm going to draw the customers to me. I'm going to take advantage of the fact that you've developed all this goodwill. And what happens is your consumer is in the store at the shelves, and there's two trademarks, and they look very similar, and the consumer gets confused. That's not okay under the law. That is not okay under the law. So what happens is now your trademark is actually giving you the advantage, and it's kind of inflicting some pain on your competitors, because now you're in a situation where you can file claims for trademark infringement, and because there's artwork involved here, copyright infringement as well. All right, so I kind of did some stories about how all these sort of things come up, but really I wanted to get you to the point of that first question, which is assessing the risk, and then deciding, assessing the costs and the time risks of trying to get protections for your intellectual property against how you're going to use your intellectual property to establish yourself in your market. All of the intellectual property that I either hinted at or discussed in more detail has a process. So patents, you have to file a patent application. You cannot get patent rights without a patent application. Trademarks, as soon as you use a trademark, you have rights in the trademark where you're using it. If you want national rights, you file a trademark application. Trade secrets, you have to put controls in place in order to protect your secret. Without those controls, the law may decide that you actually don't have a secret for something that's bringing economic value to your business. Copyrights, as soon as you write that code or draw that diagram or create that 3D model, you have copyrights in that authorship. If you want to sue somebody, that's when you have to file an application to register for copyrights. So there's processes for all of these, and it just really, again, it goes back to you have to balance your risks of whether or not they're going to give you the business benefit you want versus the time and the resources it takes to go through those processes. All right, so at this point, thank you very much for listening to my presentation, and I'm going to hand it back to Chad on to Eric.
Great.